Good morning, everyone. We will momentarily convene this public hearing of the Government Administration and Elections Committee. We have 6 bills for review today, public hearing today. I believe that Stephanie Thomas, Secretary of the State, is first on the speaker order today, but I do not see her quite yet, so we'll give her a moment to get on if she is attempting to do so.
She is here, Matt.
Great. All right, Madam Secretary, you are first in the order. I know we're kind of operating a little out of the ordinary here today. I hope everyone is staying warm and dry and off the roads.
No problem. I thought I was number 2, so I just want to make sure I'm not going out of order.
No, sorry. We received notice from the first speaker that they are actually not going to be here today. So apologies for any confusion.
No problem. Good morning, co-chairs Flexer and Blumenthal, vice chairs Honig, Morimbello, and Osborne, and ranking members Sampson and Mastro Francesco, and all the members of the committee. I'm here today speaking on behalf of SB 224 and 226. SB 226 simplifies and standardizes regulations around a lot of problems that have presented themselves over the years. These are repeat proposals from last session where I did testify. I submitted our written testimony. I'll be happy to answer questions at the end, but in the interest of time, I just want to note a few things that are different. One, I looked at CTCA's testimony about SB 226, and I would have no objection to their suggested tweak in Section 4 that would allow the town clerk to be the tiebreaker if registrars can't decide on an early voting location. And I also want to address SB 224 in sections 24 and 26 of SB 226. And this has to do with ballot privacy and the voter file, the public voter file. I saw in some of the testimony that were opposing these measures a few things that I'd like to put on the record. I disagree that protecting the secrecy of the ballot and protecting private voter information has limits transparency. I do believe the public absolutely has a right to know election outcomes and how elections are administered, but I don't think we have a right to inspect how our neighbors are actually voting. The secrecy of the ballot is foundational to both voter confidence and to keeping elections free from intimidation and coercion. So both of those measures, so in section 24 of 226 and 224, what we are attempting to do is protect the independence of the individual voter. There are many other ways to audit and verify elections, from tabulator testing records, reconciliation logs, post-election audits, seek investigations, and court-supervised reviews. So this bill language is basically just working to ensure that all ballots are treated with the same privacy protection instead of protecting only some ballots in some types of elections. It would also limit the opportunity for stray markings to be used as signals in vote buying schemes, and I'm happy to talk about that more in the question period. And with regard to Section 26, what we're proposing is not groundbreaking or new compared to most states. Connecticut is on the lower end of the range when it comes to what's available in our public voter file. The majority of states already have rules about restricting commercial use. And when it comes to providing the full date of birth in the public file, experts have been advising against it for years. States that already exclude day and month or date of birth altogether: Alabama, Alaska, Arizona, Colorado, Delaware, DC, Georgia, Hawaii, Indiana, Louisiana, Michigan, Minnesota, Mississippi, Nebraska, New Hampshire, New Mexico, North Carolina, North Dakota, South Dakota, Vermont, Wisconsin, and Wyoming. And others restrict this information for certain people who purchase the file. So over the last few years, as I've been secretary, I have continued to work closely with administrators in our 169 towns, but also election officials across the country, red states, blue states, purple states, everything in between. And all of the proposals that we've proposed here are based on best practices that are designed to strengthen our procedures, clarify a process, or close gaps before those gaps become problems. So I urge you to support SB 224 and 226, and I'm happy to answer any questions.
Thank you, Madam Secretary. First, we'll have questions from Senator Honig, then Representative Master Francesco, and then anyone else who raises their hand. That looks like Senator Sampson will be after that. Senator Honig, whenever you're ready.
Thank you, Mr. Chair, and thank you for being here, Secretary of State Thomas. In the last municipal election, I volunteered as a poll worker in Simsbury during the municipal elections during the early voting. And one of the big asks from the registrars there was around electronic poll books. And they thought that this would be a huge kind of work saver for them as opposed to the way things are currently done. And I believe that the electronic poll books do not require any legislation to kind of start using them here in Connecticut, but just wondering if you could speak to that.
Senator, it's outside the scope of any of the bills before us, but I would be happy to set up a time to talk outside of this hearing because it is a long explanation. But thank you for the question.
Okay, appreciate that. Thank you, Mr. Chair.
Thank you, Senator Honig. Representative Master Francesco, followed by Senator Sampson.
Thank you, Mr. Chairman. Madam Secretary, it's nice to see you. I'm glad everybody's here via Zoom. It's a little bad outside. Just a couple questions and clarifications on Senate Bill 226. First, I want to say that I think it's good that the early voting, when people go in to vote, that they're putting their ballot right in a tabulator. I think that was a big problem over the last couple of cycles, and it certainly will help get our results obviously much quicker. I do have a couple concerns with the bill as it's written, specifically on Section 1. And I believe that at the end of the day, the tabulators, the ballots that are in the receptacle are to be removed. That's different from the process right now. Right now, I believe the process is that those receptacles are put in a secure place and nothing happened. But now what's happening is those ballots are actually going to be removed on a daily basis. What is the purpose of that change?
And I'm going to make sure my director of the lead division is pulled in as a panelist, Kristen Sullivan. But actually, and Kristen, please jump in if I'm misspeaking, okay. But it's the same requirement. So right now, many towns are too large. The ballot receptacles can only store so many ballots. So those ballots are removed, but there are strict chain of custody. They have to be, with early voting, actually, they have to be segregated by day into sealed bags. Those seals are tamper-proof, and literally every day has to be segregated in case there is any sort of audit or anything like that. So this does not change that. It mirrors what currently exists. Kristen, feel free to chime in if I'm.
No, I think that that's right. And, you know, having looked at the laws in other states, it represents chain of custody best practices for states that do use voting tabulators for early voting, where, as the secretary mentioned, you know, you'll need to take care of address the fact that each day the tabulators are have ballots put into them. So we want to make sure that both the ballots themselves as well as the tabulators are following chain of custody best practices. And I think that this represents that.
And Kristen, can you just identify yourself for the record?
Sorry. Nice to see everyone. Kristen Sullivan, Director of Elections for the Secretary of the State.
Thank you. So through you, Mr. Chairman, the concern that I have is currently when you put them in the receptacle, they're sealed right now, right?
No.
They're in an envelope.
Oh, I see what you're saying.
The
Yeah.
early voting
All right.
ballots are secure. They are in an envelope.
I'm sorry, everyone. If we could just make sure that we speak through the chair so that we can preserve a clean record. Thank you to both of you.
Got it.
So through you, Mr. Chairman. So right now they're in a sealed envelope. The concern that I have is they are no longer in a sealed envelope. They are put right through the tabulator and put into receptacle. So there's no privacy. There's no, you have two people, I guess, is it both register of voters have to open the receptacle at the end of every day. And technically you can see the votes because they're not in an envelope any longer.
Through you, Mr. Chair. So that is correct. They are, so the procedure would mirror what happens on election day, where same thing, ballots not in envelopes are placed into secure pouches, if you will, and locked away until counting.
Thank you. Through you, Mr. Chairman. So currently on election day, there are ballots that are, let me just ask you this. How many towns have a problem when the receptacle is full on election day that they feel that they need to take them out? Do they use an additional machine? Or some people only have one tabulator and they can only use one, they have to take it out. What has been the problem over the years?
Through you, Mr. Chair, and again, Kristen, back me up. I would assume that every town in Connecticut has that problem on election day because no tabulator can store more than a couple of hundred ballots.
That's right. And so as they go through the tabulator, they are going into secure receptacles or pouches that are then for each day locked to maintain the strict chain of custody procedures. So in other words, they are the privacy is maintained in that respect day to day.
Thank you.
And those receptacles are locked each day.
But Kristen, I just want to clarify, but also on election day, like pre-early voting, same thing.
Yes.
Thank you. And so through you, Mr. Chair. So, Madam Secretary, you said pre-early voting that they're locked in a receptacle. But again, as I mentioned, they're in a secure envelope. The problem with it is that you're correct that on election day, if the receptacle gets full, they only can have a couple hundred. It's election day. That's the day. And at the end of the day, they'll all be counted. You're talking about allowing these ballots to be taken out of the receptacles every day, and I'll just say the state election for 14 days. You had mentioned earlier when you were talking about the Freedom of Information bill that the purpose of that is to protect the voters' privacy and to you wanted to protect the individual vote so people can't see on it. How does that differ from something like this where you're able to open that receptacle every day? there's many towns there that have very few early voting and on a daily basis. I mean, we've seen it. Some towns, maybe they're very small. They only had 1 or 2 people come in that day. Now, at the end of the day, you're taking those ballots out. You can actually see who they voted for because you know who voted that day. How does that differ from the argument on the freedom of information side?
Through you, Mr. Chair, the registrars of voters are tasked with following the law, and they would do that whether an election is 1 day or 14 days. So their integrity will not change as the length of time increases. With regard to the Freedom of Information Commission testimony, that has to do with differentiating between which elections a ballot is considered private in terms of an individual requesting to see it. So very different issues.
Thank you. And through you, Mr. Chairman. So I would say that, I want to say that I'm not questioning the integrity of our town clerks or our registrar of voters. Obviously, I believe that they do their job. My concern is that ballots hanging around for 14 days, every single day being taken out of those receptacles. And as we all know, many elections, I'd say pretty much every time there is an election, there's a recount most of the time. I understand that those votes are already tabulated and it's just a matter of putting the ballots out. But to me, it's a possibility for you can have voter fraud. You can have somebody replacing those ballots. Not saying anybody can get into that area. But, we don't know. There's 169 towns. So I certainly have a huge concern with those receptacles being open every single day. I understand, though, in a course of a day, if it was full, obviously something needs to be done. But there's a lot of towns out there that have very small voter turnout for early voting, and there's no need to remove those ballots from the receptacle on a daily basis. Maybe an exception would be given if the receptacle was full. I can understand that, but it doesn't need to be across the board blanket for the entire state. So I do have a really big concern about that particular meeting.
May I just add one point here that might be just to clarify? When that is done, it's always done by bipartisan teams of registrars. So you've got folks on both sides. No one person is doing it themselves. So you've got that safeguard in place as well.
And through you, Mr. Chair, I'll just add that the security requirements are greater under early voting than on election day, with the segregation and the nature of the sealing and how it has to be locked away. There's also a recommendation from the Town Clerks Association that since many early voting ballots are currently stored in town clerk vaults, that be extended with any change in the law as well, to even make it more secure. I don't think security is at issue here. And there was something else you said I was going to address, but I forget. So thank you.
Thank you. And through you, Mr. Chairman. Again, I am not questioning the integrity of our town clerks or our register of voters. I'm not. I'm questioning the chain of custody. As we have seen sometimes when there is a recount, ballots are found in other places. We've had that happen before. They tabulated it, and then all of a sudden ballots showed up elsewhere that they shouldn't have been. So things could happen through no fault of your own, but it certainly is a concern of mine. Through you, Mr. Chairman, I had a question to the Madam Secretary on section, I believe it's 26, when it talks about the, I guess on lines 1453 down to 1465, that voter registration information is only to be used for election-related, journalistic, political, and governmental purposes. When you talk about governmental purposes, what do you mean by that? Through you.
Through you, Mr. Chair, I've remembered the other point with your last sentence. part of the reason the security of the ballots during early voting, the way the regulations were written was to store them securely, segregated by day, with bipartisan oversight and with tamper-proof seals, was that there was a lot of concern expressed in 2023 when we were first looking at this about the security of leaving ballots in a tabulator overnight. At that time, a lot of towns and legislators were concerned about, one, the cost that towns might incur, because some were saying if we're leaving ballots in the tabulator for 14 days, we want video surveillance on that tabulator. So by mirroring and adding added security to what typically happens on election day, that was part of the conversation to make early voting more secure, not less secure. Regarding lines 1453 to 1465. So a lot of states have statutes that are similar. So we looked at, as I said earlier, the majority of states already have laws like this on the books. So we looked at a wide variety of other language, and we also spoke to other states. And part of what was recommended to us is that you can't predict every situation that will happen over the course of decades, and that the more specific the language, the more problematic it has turned out to be, where uses that might not have been even dreamt of like 10 years ago came up. So we literally took this language from many other statutes around the country. So governmental purposes. So it's not defined closely, specifically.
Thank you. Through you, Mr. Chairman. So, but who decides what governmental purposes are? Who makes that decision?
Through you, Mr. Chair, in this legislation, our office.
So your office will determine what's considered governmental purposes, which to me is, it should be defined more clearly in the language, that it shouldn't unilaterally come out of your office. So that certainly is a concern. The other part is that when somebody obtains a voter list, what do you consider, who do they obtain this voter list for? What voter list exactly would be under scrutiny under this, would qualify for this?
Through you, Mr. Chair, this relates to the publicly available voter file. So I think everyone knows that in, I believe, every state, you can buy the voter file. It's a public document. Here in Connecticut, it costs $300. Every state is very different. The most any state charges is $37,000, which is very interesting, and we should look at it as an income opportunity. But in the voter file itself, so most states, as I have said, restrict the commercial use. It's also seen as a best practice as technology has changed to also not include the full date of birth. That list of states I read earlier, those are states that don't include either the full date of birth or the month or the date. And the reason this is now recommended as a best practice, I don't think I need to tell everyone that scams and huge criminal enterprises are undertaking phishing scams, ransomware, etc. So when that information is publicly available, what the experts are saying is it makes it very easy for individuals to fall prey to everything from telemarketing to phishing scams, etc. So when they look at balancing voter privacy with transparency, they think it's fair to either redact that information, but we're not even suggesting that we go that far. We're saying just leave the year.
Okay, thank you. And through you, Mr. Chairman, I guess what I'm trying to figure out here is that we are prohibiting a commercial or a private company from using that list to send out marketing material. Maybe it's not election related. Maybe it's for their products or services. What is the purpose of doing that?
Through you, Mr. Chair, the same reason, basically. Think about it as mailed telemarketing. And again, there has been, I would say, I don't think there's been studies per se, or at least not that I can cite, but a lot of individuals have expressed concern that when they register to vote, that information is being sold off to people to just blanketly market to them. There have also been some criminal cases where, for example, someone was able to stalk someone simply by obtaining their information in a voter file. And, you can imagine very easily the types of scenarios that could occur. And again, this language is modeled after what most of the country is already doing.
Okay, thank you. So I guess through you, Mr. Chairman, how do you track this? How do you know if a company or a commercial company is using a voter list to target someone? How is it trackable and how is it enforceable?
Through you, Mr. Chair, I think like many laws that are on the books, you cannot police every incident. Like we can't police if everyone is wearing seatbelts, but if a crime is committed or someone raises a complaint, then you would have to back into it. We won't be able to police it, but it gives people an opportunity to fight back if someone is using it outside of the limits of whatever law we pass.
Thank you. So through you, Mr. Chairman, so here's the issue I have. So those lists can be used to target an individual for political purposes, campaigns and so forth.
Mm-hmm.
And maybe they're specified, they're targeting them on a certain topic, whatever the topic is.
Mm-hmm.
But that's okay to do that, but it's not okay for a private business to target an individual to sell their products or services. But we can target them on a political issue. To me, it doesn't make any sense. It seems to me that it's also a violation of freedom of speech. Do we have anything in place right now? Because this seems like to be new language, and I wasn't sure if we already had something in place that prevents this.
Through you, Mr. Chair, one, I also personally would not agree with political targeting of messaging, but the reason political parties and candidates have been exempted in other laws around the country is that many parties and candidates use that information to do things like help get out the vote or reach out to people about their actual campaign versus sort of spamming them, and that is why they have been allowed in the statutes. I think Connecticut could certainly talk about if they wanted to remove parties from this legislation. And then, Kristen, I'm going to turn to you. I don't recall offhand if there's anything or what's currently on the books with this regard.
Let me check and I'll get back to you all on that. Hopefully I can check real quickly. The one thing I did want to just circle back to your question, Representative, about how to police it, as the Secretary mentioned, it gives the opportunity for someone who is thinks that their right might have been violated pursuant to this legislation, to go to State Elections Enforcement Commission and ask them to investigate, just as they do for other violations of Title IX. So there's that protection there.
Okay, thank you. And through you, Mr. Chairman. So, Madam Secretary, I would disagree. The bill clearly says that it may only be used for election-related material. So election-related, we all know that our candidates are not going out there just trying to get people to come out to vote. They're always talking about political issues and topics. So they're selling their ideas to people. And yet a business cannot target someone to sell their products or services. To me, it's I just think it's egregious, to be quite honest with you. And then there's also a fine on there of up to $2,000. How would you enforce that? How would you? I just don't even know how you can even enforce something like this. It seems like it's a violation of freedom of speech. You're preventing a business from soliciting advertising, putting something out on social media that they're targeting a voter. As we all know, I mean, crazy it is, we know our phones are listening to us. Somebody says, hey, I went out and registered to vote today. And they're probably being targeted for whatever. Political targeting is huge, and they're doing it every single day. It just doesn't make any sense to me.
Through you, I just want to clarify. So line 1454, election related is different. I think of that as something like our office sending something election related. It also allows use for scholarly, journalistic purposes, other governmental purposes, and then political is carved out as its own entity. I just wanted to clarify.
Thank you. It's clearly election related, and the word alone is election related is not defined in this bill. Political, that's not defined. That could be anything. You could be targeting somebody for, maybe there's a question on the ballot for a constitutional question, and there's people sending intimidation letters out. Let's just say the one maybe for an abortion, we'll say, right? Sending out the candidates can send out a mailer scaring, intimidating people that their abortion rights will be violated if they don't pass this. That's intimidation. That's political. There's no definition in here of political. So.
Through you, I would not be against making this stricter. As I mentioned, this is not the strictest law that exists in the country limiting the use. There are many that have very strict limitations around who can use it. In fact, you can't even receive it in any form. You can only go to one location in the state and read it. So if you want to make this a stricter parameter, I'd be happy to have that conversation.
Thank you. Through you, Mr. Chairman. So to using this for any personal, private, or commercial use, personal being there's an let's say organizations out there, maybe nonprofits, targeting certain voters on political issues, they would no longer be allowed to do that?
Through you, Mr. Chair, if those uses were outside of these parameters, that is correct.
Okay, but a nonprofit or an organization can target someone on a political ideology or maybe a law that's coming to pass, a question or a referendum, they can target a voter using it that way. But a business, again, cannot target a voter to purchase their products or services. It's insane.
If I may just quickly jump in here, there are other laws that prevent voter intimidation and harassment that would certainly come into place here under Title IX. If you look at Chapter 151, which talks about prohibited acts and penalties. So this provision would not exist outside of any of those prohibitions, which, for example, prohibit the interference with electors in voting and those sorts of things. So those are already existing law.
Thank you, Kristen. And through you, Mr. Chairman, I believe that those laws, and correct me if I'm wrong, now this is expanding it into print, digital, social media, audio, and visual. Am I correct in saying that through you?
Oh, are you asking me?
Oh, yes, I'm sorry, yes.
I would need to take a look at those statutes that I'm referencing. I'm not sure that that they don't cover all of these things. I think that they're pretty general.
Okay, thank you. So then this, that's what I'm trying to figure out here. This
Right.
is very new language. I know there's probably laws on the book right now about intimidating a voter, and that's most that I understood is mostly at the polls. But this now is expanding language to prevent someone from advertising, basically. To me, that's a violation of freedom of speech, in my opinion. But I listen, I appreciate you taking the time to talk to me. I'm sure my colleague has other questions on it, but you did clarify. But again, those 3 sections are really a concern of mine on this. Thank you. Thank you, Mr. Chairman.
Thank you, Representative Master Francesco. Next up is Senator Sampson, followed by Representative Manapace. Senator Sampson.
Very much, Mr. Chairman. Before I ask a question of the witness, normally you offer us an opportunity to say a word at the start of this meeting, but you didn't. And I'll just be very brief, but I do want to express my concern over actually having this hearing remotely today. I didn't appreciate when we passed this legislation a few years ago during COVID, and I'm just reminded again today that this is a disservice to the public. There's a great many people out there that do not have the technology to participate remotely, and those people are being left out today. I also think that it is very important that the people of our state have the ability to face us in person in the committee hearing room at a public hearing if they so choose. And by having this meeting entirely remotely today, I think we're eliminating that very, very important part of our system of representation. I just wanted to put that on the record. It remains a concern of mine, and I hope that someday we go back to more common sense where we require the public officials to be present and available to the people. Hiding behind electronic means, it to me doesn't make a lot of sense. I do appreciate the fact that it does allow a lot of people to participate that may not have participated before because of the benefit of Zoom and new technology, and that's a good thing. But it should never replace the original way of doing business, which is face-to-face interaction and representation. I just thanks for the indulgence. Let me just get that on the record. Madam Secretary, good morning.
Morning.
I appreciated the dialogue between you and Representative Mastro Francesco. I think those are important things. I do understand that some of this is hard. It is kind of the problem. And trying to find the best solution to solve, for instance, the question of how do we deal with early voting and the fact that there will be ballots that exist for 14 days, 13 days, 12 days, and so on when people come to vote, and how to handle that is not something that's easily solved. I noticed there was nothing in your proposed bill about adjusting the length of time on early voting. Through you, is there any consideration to that point?
Through you, as you know, only committees can raise bills. We have put in a lot of technical fixes as well as many other possibilities. I would expect that if something were raised around early voting, it would not be in this bill, which is more technical in nature. But that would be up to the committee. I have certainly always from day one had many thoughts and proposals about the length of early voting. I do think if this committee and this body raises universal access to absentee ballot law, that provides an opportunity to look at how one might amend early voting, because absentee voting creates in-person early voting in a very real way at the town clerk's office. So I would expect that debate to come up later in the session.
And I'm sorry, just to interrupt very briefly, I didn't want to interrupt either of you while you were speaking. Just for everyone listening, I know I just wanted to briefly respond to the good Senate ranking member's comment. I know that there are members of this committee and members of the General Assembly who have always disagreed from a policy basis with us having fully remote meetings, but I just want to assure everyone for the record that to the extent that they are enshrined in our rules and the law, that the committee did comply with all the rules and the law in order to have this hearing fully remotely. The closure of the building was announced yesterday, and as a result, we decided to hold the hearing remotely to ensure that everyone could participate without getting out on the roads in these difficult conditions. And we did reach out to all the individuals who were signed up to testify to ensure that they could participate remotely to the extent that they were interested in. So I don't want to, I'm not disputing the wisdom of having fully remote hearings or any of the policy, and I accept and understand the senator's objections, but I just want to assure everyone that as it is enshrined in the rules were followed. And thank you for the indulgence. So Senator Sampson, you have the floor.
Thank you very much, Mr. Chairman. I will not debate you at this point. We both said our piece, and I will leave it at that. But it is a worthwhile debate to have at some point. Just following up on that, so through you, Madam Secretary, I appreciate your comments about the committee raising legislation and so forth. But this Senate bill, what is it, 226, was presented to me kind of as your wish list for policy changes. And while I understand that a lot of it is somewhat technical, I mean, these are policy decisions. The decision to remove individual dates in dates of births, that's a policy decision. That's not a technical thing, for example, or to bag the ballots out of the tabulators each night. So are these not your requests? These are requests coming from the committee through you?
Through you, they are. Maybe I misspoke. We probably have 30 to 40 requests between last year's session and this year. And some of them are here, and I am hopeful that the rest will show up somewhere else.
I appreciate that answer. And through you once again, I'll just say that the reason why I wanted to kind of clear that up is because it's kind of informative for me to understand both what is here, but also what is not here. For me, there's some what I think are glaring items that need to be addressed. And maybe we'll touch on those at the end of our conversation. But I want to follow up initially on Representative Mastro-Francesco's questions, which center around Section 1 and Section 26, I think it is. And I appreciated your answers to all of the questions, although it seems a little inconsistent to me, frankly. You know, the idea of protecting the privacy of the voter as a registered voter, but then having less concern about the privacy of the actual ballot. To me, though, that's where things are flipped. We seem to be putting too much emphasis on determining that whether or not a voter's identity is known. I think you said on the record, which I thought it was an odd thing to say, that said something about knowing how our neighbors are voting. Well, the fact that somebody's date of birth exists doesn't tell anyone that how our neighbors are voting. It might tell us that our neighbors are voting, or at least that they're registered voters. But I mean, I think it's a universal idea that we want to encourage voting. I think we have other bills on our upcoming agendas. There's even one about universal voting, I think. You know, so I just want to get you on the record maybe a little bit more, explaining to me why it's so important to remove this date of birth in Section 26. Through you.
Through you, let me clarify. the statement I talked about the statement I read about not having our neighbors know how we vote has nothing to do with the date of birth provision. There is a separate decision that has been made by the Freedom of Information Commission, and you can reference their testimony. There was a case earlier or late last year about whether or not a private individual had the right to see the actual ballots of that were cast in an election. And their ruling differentiated the privacy of the ballot between referenda elections and other types of elections, and absentee ballots versus ballots cast in person. So what the how your neighbor voted comment was about a private individual being able to access some ballots but not others. And what we are seeking to do is make all ballots uniform, meaning some are not more worthy of privacy than others. Regarding the date of birth provision, as I mentioned, it's just been recommended as a best practice in election communities for years now because of the escalation of all types of attacks and scams, etc. And for many legitimate purposes, you don't need the full date of birth. So in order to try to cut down on some of that, states started, even Connecticut removed the date, and right now existing law is the month and the year, but many other states removed date of birth altogether, or they removed the month and the month and the day and kept the year. So now we are saying that we should catch up to what many other states are doing and just limit it to the year. As I mentioned earlier, also to the representative, ours is still on the very low range of protections. Many states have much, much stricter protections, with the expectation, or I guess that, I don't know why every state came to this decision, but what I hear anecdotally is that when voters register to vote, they don't expect that their information is so easily available to people to use for telemarketing and other purposes. And I take the representative's point very well. I think they also wouldn't like to hear from candidates so much. And as I mentioned, if you want to make those laws stricter, I would be happy to have that conversation as well.
Thank you very much for that answer through you, Mr. Chairman. I appreciate where you're coming from. I think it's a little bit of a stretch to suggest that the information that is on the voter file is somehow so secret or secure that it is leading to scams, or that there's experts that are warning against it. I'd love to hear or identify the experts that you're referring to. I mean, people put their birthday on Facebook every day. I mean, even if not everyone's information is there, if scammers are looking for a target, they don't have to look too far. I don't know that phone numbers are actually part of the voter file necessarily either. I think that some may be, but I don't think there's a requirement for someone to put their phone number on the voter file. So telemarketing, for me, I just think it seems like, while in the interest of trying to protect privacy, quote unquote, which I agree with, you're also limiting the ability of people that are out there in the world that are actually trying to monitor our election process for its integrity. And if you're making it harder for them to identify the voters, then how can they identify whether the integrity of our election is legitimate? I think this is all part of the same puzzle, which is that, if in order for people to really have faith in confidence in our election process, which they don't, rightfully or wrongly, we could debate that, but people don't have confidence. I think you have to make sure that there is a mechanism to be able to connect the individual voter with the results. And this, for me, just speaking with people who work independently out there in the world who track elections, they see this as a mechanism to limit their ability to track the voting integrity. Do you have a response to that through you, Mr. Chairman?
Sure, through you. First, I would say that it's not a fact, but we could debate how many people do and don't have trust in elections. But especially here in Connecticut, where we have something that is so unique in the rest of the country, which is this bipartisan group of election administrators in every town in Connecticut. That makes the Connecticut system very different than most others. But in terms of I'm totally blanking. You were talking about I totally blank on your
Through
last
you,
question.
Mr. Chairman, I was asking your reaction to people that track election integrity.
Oh, yes,
and
thank
their
you.
ability to see the voter information.
Thank you very much. Through you, this language very specifically does not bar journalists who do a lot of post-election work in terms of putting data out and parsing out information. It does not bar scholarly usage. There are many, many entities on both sides of the aisle who are constantly vetting election results, election data, and putting out content, whether it's something like the Heritage Foundation or something like the Brennan Center, and they're publishing papers, putting out white papers. There are universities writing reports and doing exhaustive searches, so that is not barred. Governmental purposes are not barred, so I could envision a scenario where there might be a governmental entity. Like if you think about a lot of the work that Brad Raffensperger has done in Georgia around their voter lists, like parsing out a lot of different data. And I could imagine other think tanks and that type of thing, but it all falls into scholarly, journalistic, governmental purposes.
Thank you very much. Through you, Mr. Chairman. I appreciate the answer, although I don't know if we got to the source of the question, which is how does somebody who is interested in monitoring an election, determining who the residents of a specific town or legislative district, for example, identifying those voters and matching them with the votes, not how they voted per se, but the fact that the number of people that voted was correct, and that the only eligible voters were voting and so forth. Again, I don't want to beat a dead horse, and I certainly don't want to trade barbs with the good Madam Secretary.
No,
I will
but
just say in response to your comment about the confidence in our elections. I'm the ranking senator on this committee, and I will tell you, I don't have as much confidence in our election process as I'd like. I think our election process is pretty good, but I don't like our absentee ballot situation. I think that the ability for entities, and I know this is something you probably agree with me on, the idea that you can have third parties and candidates willy-nilly sending out ballot applications to every person on the voter list, whether they're alive or dead or duplicative or have the right address, is an invitation to fraud. I think that's a problem that needs to be addressed. The failure of having voter ID is something that I think is a concern of the vast majority of people across this country. There's recent polls, the people in Washington debating the SAVE Act. Even a majority of Democrats believe that we should have photo identification at elections. So to suggest that somehow Connecticut is above average in the idea of voter integrity, to me is not even remotely accurate or confidence inspiring. So again, I don't want to trade barbs, Madam Secretary, but I mean, we don't agree. And I don't think it's safe for you to say, as the Secretary of State, that our elections are everyone's confident in our elections. I'm telling you, I don't want to say that I'm not, because I know that'll be used out of context. I just say I'm not as confident as I'd like to be. And there are things that we ought to be doing. Let's talk about this governmental purpose thing really quick. Through you, Mr. Chairman, why did we write the statute to empower the Secretary of State's office to determine what a government purpose is, rather than actually stating it by definition? Through you.
Through you, I did answer that earlier, but basically the advice that we have found from states who have had similar statutes on the books for much longer than we have was that they found that there are uses that you might not be able to predict 5 years, 10 years hence, and that the more specific language actually could have the unintended result of restricting things that you might not have thought should be restricted. So that is why it's general. And then to answer your other question about if there are people who want to have access to tracking elections for the purpose of making sure like everything is copacetic, don't forget, we're just talking about taking away the month. I'm sorry, yeah, the month of
Yes.
the date of birth. The year would still be there, and because of the way elections are administered in Connecticut, very different than like Texas, for example. So anyone could still have the name, the address, the year of birth. And I think if there was some discrepancies where, I mean, I can only imagine it would be a very small group of people who had the same name, address, and year that were in dispute. Maybe the case of some twins or something like that. They could always go to their election workers and query for additional information. So I don't think we're restricting any of that use as well.
Madam Secretary, if I could just build off of that, that's what I was going to say. We're not, we're retaining the year of birth, so it's not going away altogether, just getting rid of the month of birth. So that information would still be available together with names and addresses. So people would still have the ability to, have that information. And on top of that, our office, just practically speaking, has heard from, hundreds and hundreds of voters who have concerns about this information being out there. So I think it's, useful just to have that context about voters who are concerned about this.
And I appreciate the answer. Through you, Mr. Chairman. I understand what you ladies are saying very clearly, and I appreciate the answers. I'm on a fact-finding mission more than trying to debate you. I'll just point out that I think that I think the same argument can be made in the exact opposite direction, which is that if it's a very tiny, tiny population of people that could not be identified as a result of these changes, then why bother? So I really don't see it. I don't think having date of births it does anything except for allow people that are tracking elections to make sure they can identify individuals. And when you have a date of birth, you start losing track of individuals, and that's what's important to the integrity of our election process when it comes to an auditing kind of standpoint, as far as I'm concerned. But let's leave that one aside. Let's go back to the governmental purpose thing. I heard the secretary say, that in the future, governmental purpose might mean something different. This legislature meets every year. The majority in this state, passes legislation willy-nilly. In fact, we're going to go in on Wednesday, and this exact bill, maybe with a word or two changed, is going to pass on an emergency certification. There's no difficulty in making a change if the definition of governmental purpose needs to be changed. That's the reason why the legislature meets. This is a big problem I have with the way this majority operates, frankly, is that they are constantly removing what is understood as definitions that the public can rely on to determine the rule of law and replacing it with the arbitrary decision of some person in a position of power or authority. The bureaucracy should not be deciding the definition of a governmental purpose. It should be written down. It should apply to everyone equally, and people should understand what it is. And I would encourage the chairs to address that with LCO and clean this up so that we actually put a definition in the bill going forward. I also noticed that in this section 26 that it seems to purposely limit this to a state governmental purpose. And am I reading this correctly, that it's purposely written to prevent the federal government from having access to this voter list through you, Mr. Chairman?
Through you, sorry, I'm looking to find, where are we? Line, 1451, section. It is clarifying that it is a state governmental use that would not be limited to the jury administration.
Through you, Mr. Chairman. So does that mean that you're refusing to provide the information to the federal government for a governmental purpose?
Through you, I'm not a lawyer, so I'm not sure we're refusing anything, but what we're saying is that it's a state governmental purpose.
Thank you very much for that answer. So through you, Mr. Chairman, I guess I'm confused. You know, the statute's being written a certain way. The staff attorneys that drafted it or whomever did was being directed to write it a certain way. And it was clearly done on purpose to indicate state governmental purpose. And I can only, you know, again, I'm a layman who follows politics, okay? And let me just say, when it comes to federal politics, I'm just a layman, is what I'm saying. And I know that there was a recent dust-up where the federal government wanted access to the voter file for Connecticut. And I don't know if it's still being disputed, whether or not we're going to hand it over to them. Which, through you, Mr. Chairman.
Yeah, through you, when the Connecticut voter files were requested, and there was a look at the statutes by lawyers who are not me, there was a lack of clarity. The thought was that the law already only applied to state uses. That was sort of the common knowledge of the statute as written. But others said perhaps not. So this is clarifying what people thought the understanding was behind the law on the books. And Kristen, please correct me if I'm misstating.
No, I believe you're correct, Madam Secretary.
Thank you very much. I appreciate you ladies clearing that up for me. But all you've done is effectively clear up that you're drafting a bill on purpose to prohibit the federal government from having access to our voter file. Am I wrong?
Through you, we're drafting a bill that clarifies what people thought the usage was, like what the acceptance was at the statute level already.
Okay. So maybe I could just follow up and say, is it your opinion that we should not allow the federal government access to our voter file? And that's why the statute's written this way through you?
Through you, that feels outside the scope of this decision or this conversation, this bill. But I will say it is on record that I have not turned over our voter file to the Department of Justice because they have requested information that is outside of that line. And we are in a lawsuit, so I cannot speak about it very much, but I would say the two are related, but not directly connected.
Thank you very much. Through you, Mr. Chairman, I appreciate the answer. Madam Secretary, you're certainly entitled to your opinion, and certainly you were elected to the role that you serve in, and you can fulfill that role to the best of your ability. But let me just tell you, as a citizen of Connecticut, one of your constituents, I have no objection to handing over our voter file to the federal government for the purposes they wanted to use it for, which I assume was to identify folks that were in the country illegally, particularly ones that might be engaged in election activities. And I think that it's shocking, actually, that our state government officials would not want to cooperate for that purpose of cleaning up our elections. I don't have any more questions, Mr. Chairman. I'll just point out for the people watching that, you know, year after year, myself and my Republican colleagues come to this committee with good ideas on to improving our election integrity, photo identification, signature verification, changing our absentee ballot process, putting actual penalties in for people that are committed of wrongdoing. And those don't appear in any of the Secretary of State's requests, as far as I know. I would certainly love to be corrected if that's the case. What I see here is a desire to block the federal government from pursuing illegal immigrants, particularly those involved in the election process. I'm not going to say that this bill is entirely bad. There is one little itty bitty piece of this bill that I think is extremely important. That's in Section 1, the elimination of the envelopes for early voting. Thank you for that, because that is a huge problem where, you know, under the current early voting situation, when you went in to vote, your name would appear on the outside of your ballot envelope, but somebody would inevitably be opening that envelope and seeing how you voted. To me, that was a shock and a shame throughout the entire rollout of early voting. It should never have been allowed. But that's neither here nor there. I'll leave my comments there today, Mr. Chairman. Thank you.
And through you, I just want to clarify for the record that there is nothing in this bill that directly correlates to the request for our voter file from the Department of Justice and our reasons for not turning over that file. As most people know, there are 23 other states and the District of Columbia, 22 other states and the District of Columbia who have also not turned over their voter files. So this bill is not an attempt to change anything about that ongoing lawsuit.
All right. Thank you, Senator Sampson. Thank you, Secretary Thomas. Representative Menapace.
Hey, thank you for being here, and very much Secretary Thomas. I just wanted to say how much I appreciated the work your office has been able to do for the municipal elections. I know, just like Senator Honig, I went and I worked in the municipal election for early voting, and I was part of the thing to be able to, in that bipartisan room where we were verifying the ballots that were coming in as the tabulators would fill up. And I can tell you that it was something that was very much voiced to me by the election workers and by the thing of the frustration of doing the early voting envelopes, and that they'd heard from so many people that they were frustrated. So I really appreciate, I know that they were very happy to see that this was on our agenda to change this rule, because I think they had kind of hoped that we would do it last year. But the question that I guess I would start off with that one is that I was very much, it's like, so is the feedback, is that the right feedback that you are getting from a lot of your registrars of voters, is that these voter envelopes are frustrating for them and for voters?
Through you, yes, Representative. We have heard from, I think, everybody, from election workers who have the added burden of opening the envelopes, which slows down the counting process. We have heard from people on the ballot because the counting process is slowed down, they get their results later. We have heard from countless individuals who were concerned that even though there are laws and processes around the opening of those envelopes to preserve privacy, much like there is for absentee ballots, people were just concerned that their name was there adjacent to their ballot. You've heard from our office and taxpayers who might not even be thinking this way, but we had to pay for all of those envelopes. So the only reason we use the envelope system was that when early voting was first being discussed in 2023, no one, including the registrars, felt confident having early voting using our old tabulators. Many of them would break down on election day, etc. The understanding was always that once we got new equipment, everyone thought it would be much better to do away with the envelope. So this bill will do that.
Yeah, thank you. And through you, Mr. Chair, I just had wanted to ask a follow up on a different section for Section 1, subsection 3. I was just curious about the language in here about the prohibit any election or primary official performing services for any political party or candidate. I'll be honest, I don't totally know if I understand. My first thought had been that would have essentially prevented someone like Senator Honig and I from being able to work in the election, but I can clarify that was not the case, but I'm still not totally sure I understand it, because I understand we're elected officials, but we're not on the ballot for any type of municipal election. But I guess I wasn't really sure if you could clarify like what this would actually prohibit.
Yeah, through you, it would not prohibit you, but I've learned not to explain election law so precisely, so I will turn to Kristen.
So it's just basically extending the same prohibition that's already in existing law under 922-58. Sorry, 9-258. So it would prohibit these officials from performing services for a party or candidate on a specific early voting or same day registration day during which they serve, or appearing at a headquarters on those days, but on no other day. So it's basically just taking the existing prohibition that exists for election day and extending it to the early voting period, but applying it just for those days on which someone is serving.
Okay, so through you, Mr. Chair. So if I'm understanding you right, the idea would be that, let's say a representative is serving as like Senator Honig or I did, like, and during early voting, that they would not be allowed to go out and say, like, go and, like, I don't know, wave signs for a candidate in that same day.
Right, performing services for a party or a candidate during a day that you're performing early voting or SDR services.
Okay, I imagine that the window of that is probably a tight one anyways, because I know how long the election workers end up working on voting day, but still, I appreciate the clarification, and I guess I did understand it in that way, just in a slightly different way. And that's it for me for that one. I just want to say again, Secretary Thomas and Ms. Sullivan, that I do really appreciate your office coming down here and doing all this work for us. I have a tremendous amount of respect for your office, and I think you guys do an absolutely wonderful job. So thank you so much for being here.
Thank you, Representative.
Thank you, Representative Menapace. Looks like there's no further questions from the committee. I have a few myself. First of all, thank you for being here, Madam Secretary and Attorney Sullivan. Appreciate all the work you've done to, first of all, help put together these policy proposals, but also being here today to explain them. Just for everyone watching and listening, we do have additional bills that have already been raised and will contain other recommendations of the Secretary's office. These largely are a set of bills or proposals that were previously heard and voted out of the committee in previous sessions, especially last session, and most of them with bipartisan support. But there will be more to come from the Secretary's office in terms of policy. So no one needs to worry about that. I had a couple questions. One was related to some questioning from Representative Master Francesco about whether and I guess the wisdom of removing ballots from the early voting receptacles every day under the new law. And it was mentioned that this was kind of the best practice across other states, but I don't think it was addressed why it's the best practice from a security and other perspectives. So I was wondering if you could just address that, please.
And Kristen, I'll let you.
Well, I think for when you have multiple days of early voting and you have the ballots being inserted into the tabulators, the tabulators will get full, and you'll need to remove them. You remove the ballots from the tabulators and put into place strict chain of custody procedures. And as we discussed, you'll need to have, bipartisan teams of election officials monitoring that, doing that. They use affidavits to sign saying that both folks were there, both registrars, or if they appoint someone in their place. And it's just an oversight precaution. It's making sure that we're taking into account that we need to account for the ballots for each day of early voting. We need to separate them for each day of early voting. So it's really, practically speaking, not possible to leave them in the tabulators. And when they're put into these security envelopes, they're not envelopes, makes it sound like they're not that secure. They're security pouches that are locked and then stored away in a locked facility. So there are a whole chain of custody procedures that are put into place consistent with other states.
And I would just add, for early voting, this is more important than election day, because should something arise where you might have to segregate for a court ballots from a certain day, that is why they are removed, because if they are just left in the receptacle, you would have no means of knowing which of the 14 days is where the ballots belong. So that is also a security measure.
Right.
Go ahead, sorry.
I was just going to say, and the turnout for early voting in 2024 at least was very high. So many towns had many, many ballots. So
Appreciate that. And certainly I think there were a couple wrinkles in a couple of isolated places in 2024. And it is always good to be able to segregate the affected ballots as narrowly as possible. So,
Absolutely.
And I think just generally, one of the advantages of our decentralized election system and having, our elections administered by 169 town clerks and 338 town registrars is that it's very difficult, and also having kind of the two-key system, the bipartisan system, each of those towns, is I think there's tremendous amount of checks and balances to make sure that an election official is not doing anything wrong or untoward. Obviously one of the disadvantages of having such decentralized system is that you have elections administered by 169 town clerks and 338 town registrars, which means that it's important to have standardization, first of all, so that everyone is reading off the same sheet of music just generally, and we have good processes. But I think also our elections officials appreciate having clearer and stricter rules so that they don't have the ambiguity and the concern that they may be doing something wrong. So I appreciate your testimony on that. Turning to section 26 of Senate Bill 226, there were some questions about that. And one of the things that was identified was the potential of your office defining what governmental purpose means. In general, I think you've indicated that this is a safe harbor, so we want it to be as broad as possible, which I would generally agree with. But I did note that bill would designate that you would promulgate, or your office would promulgate regulations. And I would imagine the governmental purpose would probably be defined through regulation, which would go through the regulations review committee and the general process. Is that your understanding as well?
Yes. Yeah, usually when something like this comes up, we do have to write the actual regulations, as you indicated. That not only goes through the regulation review process of the legislative body, but it's also open to the public. So when we have issued similar regulations, for example, there is a notice period. People have a long time to respond. We take all that feedback, we tweak as needed, and so on. So I do think that any member of the public, once they saw the regulations, it might clear up some of that ambiguity.
Appreciate that. Yeah, I just wanted to make clear for the public that this is we're not committing complete discretion to the Secretary's office. This is a publicly reviewed process, and one in which the legislature will have an opportunity to participate to make sure that we, substantially agree with your definition, which, I think generally we probably would. But
as with our bipartisan group of lawyers.
exactly. Another thing identified in section 26, one of the things I think that this bill, if passed, would allow you to do is to require that anyone who is being sold these materials or this voter information through the process have to, through the contract or through the sale, understand their obligations. And do you anticipate something like that being the case, where essentially they would be directed, when they wanted to buy the voter list, the public voter list, that they would have these obligations, that they would be able to use the list for these permitted purposes, but not the prohibited purposes?
Yes, that's correct. And Kristen, if you had something more exact in mind, let me know. But when the voter file is disseminated, those regulations would be part of that dissemination.
Agreed, for sure.
Thank you. And one, we did have a couple questions, I believe, about the provision of that section aimed at preventing the use of the voter file for harassment.
Mm-hmm.
And I just wondered, I'm not asking for you to commit on the record right now, but I guess the way I'll phrase the question is, there may be some concern and about the scope of that provision. I heard already that I believe you are considering it to be interpreted in the context of other harassment statutes. And the way I'll ask it is, are you willing to discuss incorporating by reference perhaps those other harassment statutes, so we have a clearer establishment of what that subsection means?
Yes, we'd have to have that conversation. I think on the record, this is exactly the type of thing we would sit down with our group of lawyers and work to hash out. But again, the way it's written here is mirroring laws in other states. And I think everyone is aware that there have been incidents here and there where voters have been harassed. So again, we are always trying to balance, access to information and transparency, but also voter protection. In many states, including Connecticut, there is the address confidentiality program, and programs that allow people who are victims of stalking and other crimes to protect their information from the voter file. So these types of laws get at that as well.
Appreciate that. Thank you very much. And I was wondering if you could just, we've been talking mostly about, in terms of the FOI context, Section 26 of Senate Bill 226, but if you could just address Senate Bill 224 briefly. I have to say that I was a bit baffled by that decision of the FOIC saying that basically ballots from certain sorts of elections were not subject to the general exception on ballots being FOIable. It really was not intelligible to me why that should be the case. It's kind of a Rube Goldberg machine of a decision, and I know you weighed in on it. And I was wondering if you just comment on why you think that that provision is important.
Sure. It's a perfect example of something that is a little murky in the law and that can be open to interpretation, even if the result it creates an absurd result. This decision did make a differentiation between town referenda ballots and other types of elections, but also between absentee ballots and ballots voted in person. And it was only because the statute did not very specifically include those types of ballots. And this, just to be very clear, this is not exempting ballots from any type of audits, recounts, examinations by a court, seek investigations, etc. The case hinged around a private individual who requested to see the actual ballots versus talking with the registrars or looking at the results or the results of the audit, etc., or seeking a court to intervene. And it was based on, as I recall, she was concerned that the results weren't what she thought they would be. So separately, what a lot of people aren't aware of, most states have many laws on the books already about stray marks on ballots because they had been a way for people to enter into vote buying schemes. Like, I want you to vote this way, mark your ballot with like a little check mark or something. And once we prove that you voted this way, we will pay you. So here in Connecticut, although so many states invalidate ballots with any stray mark. Here in Connecticut, it is only invalidated if it's in the voting area. But if it's like near a heading or something like that, that ballot would be counted. And if someone could examine those ballots simply by request, it could aid a vote buying scheme. So there are many reasons why we are proposing this legislation, but really to protect voter privacy and integrity.
I appreciate that. And I think voter privacy integrity is paramount. And, I think in terms of both of these provisions that we're looking at today, both the one in 224 and Section 26 of 226, I think in both of these situations, the voters would be shocked to learn that this information was essentially publicly accessible to anyone willing, to request it in the FOI context or to request to purchase it in the registration list context. I don't think that signing up to register to vote, which is a fundamental right to everyone, should subject you to potentially being spammed or scammed by some company seeking to market to you. I don't think people would imagine that's the case. And it is just shockingly easy to figure out people's personal information directly based on the public availability and saleability of the voter file on the internet in Connecticut. It is not in other states. So I think it's important that we take this measure and take this step to protect voter privacy. I think voters would be shocked if they knew what was actually going on, and it is kind of a glaring hole in our voter privacy laws. And I would also just say, related to the clarification we're trying to make through Senate Bill 224, I found your memo or your brief that was submitted in that case very persuasive, and I did not find the ultimate decision in it persuasive at all. To me, it was kind of a classic example. We heard from Justice Ecker recently on the Judiciary Committee in his renomination hearing. I thought a really excellent answer about statutory interpretation. He identified, it's a fundamental principle of law that when you're interpreting a statute, what you're looking for is the legislative intent. What did the General Assembly intend to do when it passed this statute? And that's a core principle, not only of just general kind of legal interpretation, but also just democratic accountability and principles, because we are the people voted in by the voters to actually write these laws. And if someone who is not democratically accountable, whether it is a administrative agency or a court, is straying from that, then I think it really causes harm to the democratic functioning of the government. And I just really encourage others to listen to Justice Ecker's answer and to remember those principles when they're interpreting these statutes. I just simply cannot understand, reading those statutes, reading the various opinions and briefs in that case, how any General Assembly could have possibly intended for ballots in one kind of narrow subsection to be not subject to or to be subject to anyone wanting to view them and have them through FOI, while all the rest of the ballots are protected. It just really, I couldn't understand how that, frankly, to me, absurd result could be justified by looking to legislative intent. And so I just think it's a kind of a core principle that we all need to kind of constantly think about. Here, we're going to hopefully clarify it very directly, so we don't need to worry about it anymore. But I find us often having to clarify things, which, I think any reasonable person would be like, why would the legislature do that? That doesn't make a whole lot of sense. They probably meant to do this. We all who are on the internal side of the legislative process understand that it's a messy one, and we don't always draft things perfectly. But I think the core of what everyone should be doing when they're interpreting these laws is looking to what we probably intended. There are a number of principles to do that, but that core principle has to be the most important one. So that was a very long-winded response and way of saying that I appreciate, first of all, your participation in that case and in this process to try to make our laws as clear as possible. Also to make sure that voters' privacy is protected, and also to make sure that we have the best process possible here in the state of Connecticut.
Thank you.
I thank you, the committee, for its indulgence. Any further questions for the secretary or her staff? Seeing none, we thank you very much for being with us today remotely. I will say, just also looking at the list, you are the only people who signed up, I believe, to be in person. So we hope we've not deprived you too much of that opportunity. But we look forward to hearing from everyone else. I will say, just to remind everyone, because we're a bit out of practice, when it is your turn to speak, you will be requested to agree to be a panelist through the Zoom function. Please be on the lookout for that. We've kind of already had an issue with that, and the person who has not picked up will be back in the cycle, so we'll get to that person soon. But just please be on the lookout if you're a witness for that invitation to become a panelist. And with that, we thank you, Madam Secretary, Attorney Sullivan. We appreciate you being here with us today.
Thank you so much.
Thank you.
Stay safe and dry. Bye-bye.
All right. I believe next up is Giselle Feliciano. You may begin whenever you are ready. If you could just turn on your video.
Good afternoon. Can you hear me okay?
Yes. And just before you begin, I just wanted to verify that you're pulled over. Just don't want any.
I'm just warming up the car to start cleaning it after I finish doing.
That's great. We just don't want any testimony from movie vehicles.
Okay. Good afternoon, Senator Fexer, Representative Blumenthal, ranking members, and members of the GA committee. My name is Giselle Feliciano, Registrar of Voters in the city of Hartford. I am speaking today based on both my professional experience and concerns shared among registrars as well. We strongly support the provision allowing every voting ballot to be deposited directly into the tabulator. It reduces ballot handling, strengthens change of custody, minimizes errors, and improves transparency that is a sound administrative improvement. We do support exempting ballots cast at elections, primaries, and referendums from FOIA disclosure as the reinforcement ballot's security. However, we have significant concerns with other sections of SB 226. Last session, no excuse absentee ballot voting was approved, yet no comprehensive implementation framework has been issued. There are no clearly defined standards for processing, recognition, change of custody, adjustment, or audit integration. Election administration cannot operate on assumptions. Expanded access must be matched with clear statutory structure. Without it, implementation will vary across municipalities and create unavoidable risk. We oppose requiring absentee ballot counters to maintain separate logs of rejected ballots without clear operational guidance, particularly as absentee values expands. This adds on a night strain without defined benefits. We also oppose shifting early voting locations to dispute election sites. Decisions should remain within the bipartisan authority of the registrars and town clerk, which I wasn't put on my thing, to avoid any publicity. We also oppose expanding recanvass requirements in a way that requires examination beyond the effect district. Recanvass procedures must remain targeted and manageable. Our role is not to resist change. Our role is to ensure that change are executable, uniformed across 169 municipalities, and defensively under audit and legal review. Access to integrity must move together where structure is incomplete. We respectfully urge refinement before implementation. I will answer any questions, if any.
Thank you, Ms. Feliciano. Are there any questions from the committee? Seeing none, we appreciate you being here today. Good luck digging out, and stay warm and dry.
You as well. Thank you.
Next up, we have Neil Drive. I'm sorry if I mispronounced your name.
No, that's correct, Senator. Good morning. Ladies and gentlemen, Senator Flexer, Representative Blumenthal, Ranking Member Sampson, Master Francesco, and honorable members of the GAE committee. My name is Neil Drive. I am the police chief in the town of Avon, and I am representing the position of the Connecticut Police Chiefs Association today with regard to SB 225, an act concerning fees for copying, reviewing, and redacting records created by police body-worn recording equipment and dashboard cameras. Many of you may recall that the CPCA has been a staunch advocate of this bill for many years now. It first came up during my tenure as the president in 22 and 23, has been advocated for by my successors. And again, it's an issue that is becoming more and more burdensome and time consuming for municipalities, and I assume also for our colleagues in the state police. I don't want to just rehash everything that's in my written testimony, but just as a thumbnail for any members of the public who might be listening. the Freedom of Information Act is something that the Police Chiefs Association supports wholeheartedly. But certainly the act has not kept up with the advances in technology. I wrote in my testimony that back when the Freedom of Information Act was first passed, redacting a law enforcement record usually was a 3x5 dispatch card that was time-stamped, a handwritten police report, and a mugshot. You redacted that with a black magic marker, and you got to charge 50 cents a page for each piece of paper that you produced for the member of the public. Today, even routine calls for service involve sometimes hours and hours of body-worn camera footage and dashboard camera footage that starts from the second that an officer is dispatched to the call and doesn't end until the last officer clears. Sometimes even in routine matters, there are multiple police officers present, sometimes a supervisor also. In order to effectively and properly redact that, being mindful of all the protections that are allowable under statute to protect the identity of victims and minors, every minute of that footage has to be reviewed. Items that are okay to be redacted have to be identified, and then somebody has to actually go in and redact that information, whether it's pixelating over information that is criminal justice protected information that might be visible on a laptop computer inside the cruiser. It's the victim of any number of crimes, including domestic violence and sexual assault, and minors. And again, those victims and those minors might show up on the camera feeds from multiple officers. So it's a very time-consuming process there. And again, the fact is that when the Freedom of Information Act was first thought of, and people could not possibly have foreseen what the technological advances have come to in our world today. And again, we expect this to continue to rapidly change as we go forward. So again, we are advocating. Our position on this bill has not changed. And through you, Mr. Chair, I'm happy to answer any questions that anybody may have.
Thank you very much, Chief Drive. Are there questions from the committee? Seeing none, we appreciate you being here today and support this bill, which we worked on for a number of years now.
We have.
All right. With that, next up will be Russell Blair. Whenever you're ready, Mr. Blair, you may begin.
Hi, good morning, Senator Flexer, Representative Blumenthal, Senator Sampson, Representative Mastrofrancesco, members of the GAE committee. I'm here to testify on 3 bills on behalf of the FOI Commission today. Senate Bill 224, dealing with the exempting ballots cast at elections, primaries, and referendum from disclosure under FOI. Senate Bill 226, an act concerning various revisions related to election processes, specifically sections 24 and 26. And then Senate Bill 225 about the body cameras. So just very quickly on the body camera one, we've been working on that bill for a number of years. We're in touch with the Police Chiefs Association and the state police on that. So, we don't have any objection to, to continuing to work on that. I was able to log on earlier. I heard a lot of the discussion about specifically the access to the voter list. You can refer to our written testimony for some of the details, but I think a primary concern we have is the lack of definitions. And one thing I would suggest is if you look at California's law, they have a lot of the similar purposes, but they do actually define them. And I did hear the discussion, the definitions, and if they're too specific, does that sort of box you in? I think our concern is that if you have no definitions and you leave it to one person to make the decision. I did hear the discussion about going through regulations review, which I think is good. However, at least I think the most recent version, it says the secretary may adopt regulations. So it's not saying necessarily that it is going to go through all that. And I think, again, we have concerns, how do you define, especially in 2026, what is a journalistic purpose, or who is a journalist, or who is a scholar, or what is a governmental purpose. So I think absent those definitions, and especially this year new with the imposition of potential fines, I think it could be troublesome if there's not clarity and somebody thinks that they're using it correctly, and then they could face the potential of up to a $2,000 fine per instance of where they used it wrongly. And again, that could be people who are thinking that they're doing it correctly. On the dates of birth, I understand the concerns there about the full date of birth. My understanding is several years ago, that was addressed, and the day of birth was taken out, so the month and the year is still there. We feel that that's a good compromise, to keep, a certain level of access without people's complete dates of birth, being disclosed, without any, all the identity theft and things that can come with that. And then on the ballot one, I'll just say on that, that was a very unique case. And I think I did hear, some of the comments about how the FOI Commission got to that decision. And I think, if you look at the law, I think our concern was that it wasn't addressed. And, we felt that we could not stretch the law to a place where it wasn't clear what the intent was. And the other thing, too, just to make clear to everyone on the committee, is that this was specific to ballots cast at standalone municipal referendums. So not election day ballots, not state elections, not municipal elections, not federal elections. This is specific to a standalone referendum. In this case, it was a budget referendum held, I think, in like May or something like that. And it's just, the way the statutes work is that referendum are treated a little bit differently than other elections. There's actually less oversight of referendum. And if you ask the Secretary of State's office, they will say that they don't give guidance on referendum, or they give guidance, but they don't issue binding decisions because it's sort of a different section of law. So I think on that one, I think we did look very carefully at that. It was a distinction in the types of ballots. And on that one, the way we tried to handle the voter privacy issue was, while we did allow the citizen to review the ballots, we put in our order to be certain if there was any information that could have indicated who cast a ballot, all of that had to be redacted or removed. So, that's my comments on those couple of bills there. I'm happy to take any questions if anybody on the committee has any.
Thank you, Mr. Blair. And it appears there are questions from the good House Ranking Member, Representative Master Francesco. You have the floor.
Thank you, Mr. Chairman. Thank you, Russell, for coming in. I appreciate it. I'm looking at the testimony submitted from the Freedom of Information, and there's something in here that you addressed that is concerning, and which is also concerning to me, is that in section, I guess, lines 1453 to 1461, it talks about the reproduction of print, digital, broadcast, visual, audio, and advertising. To me, it seems like it could be unconstitutional, but in your testimony, you referenced a Supreme Court decision. Would you be able to elaborate a little bit more on that? And if you have any more information on it, I think you referenced the U.S. Supreme Court has ruled on that, as also you mentioned a federal district court ruling in Hawaii. Would you be able to elaborate on that?
So the Supreme Court case, I'll confess that, that one I don't have top of mind. The Hawaii one, I did do a little bit of research before testifying today. And the one in Hawaii, that case, it was a journalist who was looking for information on the voter list in Hawaii. And the law in Hawaii at the time had certain limitations on the purposes that the list could be used for. And I think there was something in there about publication, and it was found to be unconstitutional. I'm a former journalist. I think that the reproduction thing could be troublesome because there could be times when somebody's voter information is very important to publish, right? If somebody is running for office in one district and their voter registration information shows that they live in a different district, and the newspaper wants to publish that, at least as I look at the current language, I think they'd be prohibited from publishing something like that, perhaps or perhaps not. I don't know, but I think anytime you have laws that restrict publication of information, I think of what I learned in journalism school about prior restraint, and I just think we have to be careful about prohibiting publication of information when we are saying in the prior section that people can obtain it for a journalistic purpose. So,
okay, thank you. It just seems that could be unconstitutional. Freedom of speech issue. It's concerning, but I will try to get more information on that Supreme Court decision. Thank you, Russell, for coming in. That was really the only question I had. Thanks.
Thank you, Representative. I have actually a follow-up question on Representative Mastrofrancesco's question. I take the point regarding, I guess, the potential concern of for instance, a newspaper publishing certain voter registration information related to a story that they got through another means. Would a provision that potentially limited that restriction to situations where the information was gotten through the secretary's office and the voter registration lists, at least to some extent, resolve some of your concerns there?
Yeah, I think there's probably a way to work that out, because the thing about, commercial purpose, I think based on the other testimony, there was all the discussions about businesses, but, the newspaper I worked at was owned by a corporation, and they were a commercial entity and they were trying to make money. So you'd say you have a journalistic allowance, but then you prohibit production for a commercial purpose. I'm just not sure if it lines up, but maybe there's a way to try to address that. And again, it wasn't like we were in the business of publishing individual voters' information all the time, but there could be times when it was newsworthy. And so I think and especially with the imposition of fines, because I know newspaper lawyers are very worried about anything. And I would hate to see a situation where journalists are prohibited from publishing something because an attorney says, well, now we have to be worried about if we're going to get fined, by the Secretary of State if we run this story.
All right. I appreciate your answer and your testimony, and it appears there are no further questions. So thank you very much for being with us today.
All right. Thank you, everybody.
Next up is Antoinette Spinelli. Ms. Spinelli, whenever you're ready, you have the floor.
Good afternoon, Senator Flexer, Representative Blumenthal, Senator Sampson, Representative Mastrofrancesco, and members of the GAE committee. I'm Antoinette Spinelli. I'm the Waterbury Town Clerk, and I'm here presenting on behalf of the Connecticut Town Clerks Association, which represents 169 town and city clerks who administer absentee ballots and serve as chief local election officials in partnership with the Registrar of Voters. The CTCA supports SB 224, which clarifies the ballots cast in elections are exempt from disclosure under the Freedom of Information Act. This clarification is important to protect voter privacy, ensure consistency across municipalities, and maintain the integrity of the election process. We also support with technical changes SB 226, which includes several improvements to election administration, including the option to use a tabulator for early voting in place of the current envelope system. We suggest the following technical adjustments to improve implementation of the legislation. In Section 1, for storage of early voting ballots, the bill assigns storage responsibility to the Registrar of Voters. However, town clerks already store the same day registration ballots and often have secure fireproof vaults. For consistency, efficiency, and added security, we recommend town clerks store sealed early voting ballot containers as well. Section 4, the early voting location determination. If registrars cannot agree, this act would the legislative body would make the decision. However, legislative bodies may not meet quickly enough. We recommend authorizing the clerk to break the tie to ensure timely decisions. This change is also supported by the Registrar of Voters. Section 14, submission of ballots by district. Currently, clerks prepare the ballots in collaboration with the registrars and then submit the absentee ballot to the Secretary of the State for review. All ballots are identical except for the code identifying the type of ballot. We recommend the clerk continue submitting district ballots to the Secretary for approval, which avoids duplication and increases efficiency. In Section 21, absentee ballot rejection log, we strongly recommend redesigning the absentee ballot envelopes to reduce common voter mistakes. We also recommend adding a simple, clear instruction sheet to help voters avoid errors like missing signatures or missing inner envelopes. In closing, these recommendations are technical but practical. They improve clarity, efficiency, security, and voter experience, and we look forward to working with the committee to ensure Connecticut's elections remain safe, secure, and efficient. And sorry, I'm battling a cold, so I apologize.
No worries, you came through loud and clear, as you can see, Chick.
Okay.
Next, we do appear to have questions from the committee. So Representative Master Francesco, you have the floor.
Thank you. Thank you, Chick, for coming in. Appreciate it. I'll only ask you one question because I know you have a cold, but I do want to make a comment and just say that I think you do a great job for the city of Waterbury for elections. I have to tell you, I've been down there. I've taken a tour. You've run a very well election down there. It's amazing that it's a city like Waterbury by 10:30 at night. You have all your election results, absentee ballots, early voting, no questions asked. I think people can, cities probably can learn a lot from you. So I appreciate that. Thank you very much. I just had a question for you on your testimony on Senate Bill 2224 when it comes to the freedom of information. And you talked in there that it protects voter privacy. So as I mentioned to the Secretary of State, the ballots for a referendum, there's a mark on it, right? You don't know who voted.
No.
You're probably dealing with hundreds of them. So allowing them to be subject to freedom of information, how does that protect voter privacy? I think that was a concern because nobody knows how somebody voted. It's just a circle, a mark on the ballot. So I was a little confused with that.
I believe
Through you, Mr. Speaker. Through you, Mr. Chairman.
Through you, Mr. Chairman. I believe Secretary talked about how there could be instances where someone is told to put an identifying mark on their ballot, so that if these were subject to just freedom of information in any election, would somebody, have looked at a ballot and noted that there would be an identifying mark on it, something like that is what we really mean by voter privacy. And also they are subject to audit. So these ballots are, audited. Sometimes there's recounts, recanvasses, where the ballots are going through again. And people are in the room and they're observing, they're observing the process when you have the recounts and the recanvasses.
Okay, thank you for that answer. And the other concern I had with the bill on 226 was the removal of the ballots on a daily basis from the receptacles. A concern, obviously, for small towns. Do you see that being a problem at all? Because you're talking about opening up that receptacle every single day. So let's say, for example, in the city of Waterbury, if your receptacle gets full on election day, I'm assuming that you either have another tabulator, another receptacle that you use, or you remove them. I see it being a problem from that being opened every day, especially when there's only a few ballots in there. I can understand if it was full, something needs to be done about it. But when there's only a few ballots in there, I'm concerned about the chain of custody and where those are being placed. You're talking 169 towns. Obviously, I'm not talking about the city of Waterbury, but do you have any concerns with that? It just as a whole, speaking on behalf of the Town Clerks Association. Through you, Mr. Chairman.
Thank you. I don't have concerns. I believe that emptying them into a secure, like we have these bags where they, put the seals on them after they would, just like they do at the end of the night at a polling place. If they take every ballot that's in the container, in the tabulator, put them in a bag, you're marking them by date. And I think that's important. I think it's important to have the ballots by date, in case if there was something, something that happened, I don't know what, but I don't have an issue with them. I think that is a best practice. I feel that it could be a best practice. Obviously, they would be emptying that in the room where the election officials are all together. So these would go into a bin, whether you have 20 ballots or you have 200. And I think that that's it sounds to me to be a good practice. You would store that sealed container in another secure, in my case, it would be in the vault, in a locked cabinet in the vault, where I do have, cameras and things like that, and they're sealed, so.
Thank you for that answer. And just, okay, I promise just one more, because I know you don't feel good. Do you know across the state if every municipality is using a secured pouch or an envelope they are all the same? Are they uniform across the state, do you know, or does everybody just kind of they complete putting them in a manila envelope and putting them in a safe? Do you have any idea? Or you, Mr. Chairman?
I don't know what other municipalities do. I know, what our ballots are stored in, at the close of absentee ballot counting, or at the close of early voting currently with the envelopes.
Thank you. Thank you for coming in. I appreciate it. Mr. Chairman, I have no further questions.
Thank you.
Thank you, Representative. Senator Sampson, it looks like, do you have questions for the witness?
No, Mr. Chairman, I just wanted to concur with my good colleague on the quality of work that comes out of the Registrar's office in Waterbury, and we're very appreciative. Check. That's all.
Thank you.
I will echo, it looks like there are no further questions, but I will echo those positive words. Thank you, Chick, for all your work, not only in your office, but helping bring together town clerks across the state to give us good advice on our voting laws, which sometimes we take.
Thank you.
All right. Thank you very much, and I hope you feel better.
Thank you.
Next up is Alex Knopp. Alex, whenever you're ready, you may begin.
Thank you. Good morning, chairs, ranking members, and members of the committee. I'm here to testify in support of House Bill 5221, an act reestablishing the Legislative Program Review and Investigations Committee. And I've submitted, I confess, a rather long written statement just to provide the committee with some background and history. This is the third year I've testified in support of this, and I thought some additional background might be useful. The reason I'm supporting this is that I think the General Assembly needs to take a look at whether or not the decision to eliminate the Program Review Committee continues to be the right one, given the fact that there has been such a significant change in intergovernmental relations, which has shifted so much of decision-making power on major issues from the federal government back to the states. Almost every issue that we think of as important that used to be dealt with by Congress, whether COVID health regulations or gun safety or climate initiatives or providing food assistance, is now located primarily within the states for reasons both of congressional ineffectiveness and the Trump administration's, to me, attack on federal institutions and regulatory agencies. So last year, for example, a few months ago, the legislature wisely set up a $500 million emergency fund to replace withheld or lost federal funding. Does it make sense really to eliminate the one committee that had the statutory authority to do long-range investigations with subpoena power to save $100,000 or $1 million when we're now setting aside $500 million for programs that used to be within the funding jurisdiction of the federal government? I think the decision was unwise, and I hope the General Assembly will go back and relook at this. The creation of the Program Review Committee in 1972 was part of the general trend in the country to create more powerful legislatures to be equal partners with the executive branch. And indeed, it was no accident that Governor Meskel in 1972 vetoed the statutory creation of the Program Review Committee because he saw it as a unwise growth of the legislative power that could challenge his executive authority. And indeed, all the creation of the Office of Fiscal Analysis, Office of Legislative Research, Program Review, even the creation of the Legislative Management Committee have all been really contested because these created a very powerful legislature with professional, nonpartisan staff with subpoena power and ended up as the equal partner of the governor in so many areas. I think we need to make sure that continues and that the legislature has the power to do long-range investigations, to do research about programs in other states. These are things that happen now primarily in task forces between the sessions. We stretch the resources of OLR to get this done. I think we need the PRI reestablished on a bipartisan basis so that the legislature would have this power to do it. And therefore, I would urge the legislature to reestablish it. We need the capacity in the General Assembly and can't be penny wise and pound foolish to cut off an arm that was very essential merely for the appearance of budget savings, when I think we could save much more through the review and adoption of the reports on efficiencies that Program Review in the past has done.
I apologize about your 3 minutes.
Yeah, there we go.
Oh,
Sorry.
thank you.
Wrapped up. Sorry.
Thanks, Peter. Mr. Clerk, apologies, Mr. Knopp, your time has elapsed. I think there may be questions for you, but I appreciate certainly your testimony. Are there questions for Mr. Knopp? Appears not, but I will just say thank you for your testimony. I certainly agree that it looks like, we've seen at the federal level the growth of a tremendous power imbalance between the executive and legislative branch. I think we experience it even at the state level where I think the relationship between the branches is more civil and respectful, certainly. But there is a vast gulf in resources and staffing and power and the ability to review proceedings and decisions by the executive branch between us and the executive branch. And so I certainly appreciate your testimony. And it's important that legislatures, as the most democratic of the branches and the most immediately responsive to the people, have that ability to review decisions by the executive branch.
I agree with that, certainly. Thank you.
Any further questions from the committee? If not, I would say one question. Did you submit written testimony?
Yes, I did. As I say, rather lengthy, so I apologize for it, but I try to put some of the past history. I listed some of the reports that the Program Review Committee did and re-emphasized that it's a equal, it's a rare committee. It's of equal members on both sides, equal House and Senate, and bipartisan in terms of alternating chairs during different sessions. So its work is really high quality and different than the usual lawmaking debates that go on, and therefore I think really especially valuable at this time.
Okay. I am not seeing your testimony on
I submitted it last
the page.
night.
Okay. Well,
I'll do it again.
And if we can't find it, we'll reach out and make sure we get it.
All right. Thank you.
It may also just be me failing to see it on the page. So
I doubt it. Thank you.
All right. Thank you very much.
Thank you, Senator, Representative.
Further questions from the committee? Looks like none. Like next up is Senator Gordon. Senator Gordon, whenever you're ready, you have the floor.
Thank you, Mr. Chairman. Chairman Blumenthal, Chair Flexer, Ranking Members Sampson and Mastro Francesco, and distinguished committee members. I'm Jeff Gordon, State Senator for the 35th District, 13 towns in Northeast Connecticut. And on a day like this with a blizzard, we're usually the ones getting a lot of snow as opposed to other parts of the state. But nevertheless, afterwards, I'll get out and shovel and snowblow. I hope all of you are staying safe today. I'm a strong supporter of House Bill 5221. It's an act to reestablish the Legislative Program Review and Investigations Committee. I'm proud to have introduced this type of legislation along with my Senate Republican colleagues as part of an overall proposal on many things through my caucus for ongoing efforts to make Connecticut state government more transparent and more accountable to the people of Connecticut, especially with the use of their taxpayer dollars. And this is very much needed. I hear this all the time from my constituents. Previously, the legislature had a bipartisan committee that served an oversight role. Some years ago, that committee was stopped, yet the need for oversight, I think the need for more oversight of state government, continues. And I read through every single report from the state auditors. I read that state agencies at times do not follow required laws, rules, regulations, and reporting, do not properly or fully account for money in their charge, and at times lose track of money, services, and properties. I also read that state agencies sometimes repeat these same offenses that were prior called out to them in auditor reports. And each time these things occur, especially repeated problems, there doesn't seem to be any consequence or accountability held to the state agencies other than at times when the legislature itself decides to act. And I believe this does need to change relative to the proper oversight that we as a legislature oversee and have a responsibility for in the checks and balances in the different branches of government. This can be done by reestablishing the Legislative Program Review and Investigations Committee and charging the committee to perform reviews, just not of the state auditor's reports, which I find very, very helpful, thorough, and at times very enlightening, but also enabling the committee to take actions as determined to be necessary to correct problematic situations uncovered or identified. Just not have state auditor reports that we read and then decide at some later time, do we as a legislature decide to take it up? So I do support House Bill 5221. I think it's a meaningful way to restore trust in government, but also to help government be more effective and cost efficient in what it does. And again, if we uncover problems that are occurring, especially repeated problems, this committee can serve a good role to delve into that, see what needs to be done, and guide the entire legislature as it sees fit. I ask your support for House Bill 5221. Mr. Chairman, I thank you for letting me testify today and for the committee's consideration.
Thank you, Senator Gordon, and right within 3 minutes. Are there questions from the committee? Senator Sampson.
Thank you, Mr. Chairman. And thank you, Senator, for joining us today and for sharing your thoughts on the PRI committee bill that we put in again this year. Have you reviewed the language of the bill in any kind of depth? I certainly, as a concept, we've discussed the whole idea of bringing back PRI, but I'm just curious if you're confident in the bill language or whether you've gotten that deeply into it at this point. Through you, Mr. Chairman.
Thank you, Mr. Chairman. And Senator Sampson, I appreciate your leadership and help with the Senate Republican caucus on an issue such as this, proper government oversight, proper checks and balances, and holding government accountable into good levels of transparency. So thank you for that. I have delved into the bill. I am planning to delve in a lot more detail to see some more of the nuts and bolts. From what I've seen, having read through, it didn't raise any red flags to me, but with anything, I'm looking forward to delving more into some of the details, but I'm also interested in what others have to say, including through any testimony that's been provided for today's public hearing for things I may not have thought of. And I believe for a bill like this, the devil is very much in the details, so to speak, because if we're going to want to reestablish a committee like this, we really want to make certain we're giving it appropriate charge, giving it enough room to operate, and not try to hamstring it in any way or make it so vague that the committee itself may not know what it's supposed to do and has to spend time trying to figure that out. So I know there's wiser people than me that understand this in a lot more detail, but not anything has raised a red flag right now. But again, I am looking forward to learning more and asking more questions at a later point if there's things that I do uncover through my more in-depth review. Thank you, Mr. Chairman, and thank you, Senator Sampson.
Through you, Mr. Chairman. Yeah, thank you very much, Senator, for those comments. Yeah, no, the PRI committee. I was here during its operation, and I would never served on it, but I did follow very closely what they were up to, and I found it to be very useful as one of two completely nonpartisan committees in the sense that they had equal members of Republicans and Democrats. Just looking for a reaction. You may be aware that I serve as the ranking Republican senator on the Government Oversight Committee. And how would you feel about that committee becoming an equal member representative committee with both equal numbers of Republicans and Democrats? Through you, Mr. Chairman.
Senator Sampson, I do share that sentiment. I think if we're doing government oversight, especially with, for example, that particular committee, I think it behooves ourselves to try to get rid of as much politics as may occur anytime. And I think having something like that bipartisan would make sense. I think when one is looking at government oversight, one wants to do that as fair and unbiased as possible. There may be some very touchy things that get uncovered. There may be very bland things that get uncovered. You never know sometimes when you're doing the oversight. So I do believe a committee like that could be well served in a bipartisan manner. And I think doing that can give confidence to the people we serve in state government that is there working for the people of Connecticut, that one is looking at this in a bipartisan way and not trying to, for example, stack the deck one way or the other, depending upon whoever may have a majority on a committee like that. So a committee that has that type of responsibility, I think it would be good to do in a bipartisan way, and all the better for its operation. And when it issues reports and findings, all the better if it can do that in a bipartisan way. Again, it's about trust in government and making certain that there's the proper checks and balances. I don't think anyone's looking for a witch hunt, but again, the public is looking for assurance that the work being done is good work being done, and what's being reported is good reporting. And I'm not saying that committee is not doing that, but I think there's ways to try to enhance that in the eyes of the public, and that's for the good. Thank you, Mr. Chairman.
Through you, Mr. Chairman. Thank you, Senator, for your comments. I didn't mean to throw you a unexpected question curveball, but you handled it the way I would have expected, with wisdom and with common sense. And I agree with you 100%. I mean, I think that, in the legislature, we have a number of partisan committees, and they should be. I mean, we're going to battle over a lot of political issues, and there is a wide range of opinions out there. And, that's appropriate. And, as the will of the public shifts, it takes twists and turns on how they feel about different things, so does the makeup of the legislature and the policy that we create. But there are areas where I think, to have a bipartisan cooperation, certainly when it comes to reviewing regulations, when it comes to reviewing how certain programs are working. I mean, that's the idea behind program review. And I think government oversight is something where I think we had a chance when that committee was created to make it something truly worthwhile. And I'm not saying that we don't do some good work there, but we could do a whole lot more, particularly the way things are these days, where it seems like there's another corruption story around every corner on every headline. And I feel like, if we had a government oversight committee that was dedicated to turning over each rock and looking for what's going on, we might be instilling more confidence with the public. I really appreciate your comments, and all we can hope is that these things do not fall on deaf ears, and we can move towards that situation. I'll just, as a side note, I'd say election issues are another thing that frustrate me, that we often have a lot of partisan legislation. these are the rules of the game by which we're all elected. It seems to me those are the things we ought to be able to agree on. But Senator, I don't mean to give a speech during my Q&A with you. I just want to thank you for your commitment to the legislature and your comments today regarding bringing back the PRI committee. They're very helpful. Thank you.
Thank you, Senator, and I appreciate your leadership work on this as well. Very much so. Thank you, Mr. Chairman.
Thank you, Senators. Next up, well, first of all, just make sure there are no further questions from the committee. Seeing none, thank you very much, Senator Gordon. Appreciate your testimony. Stay safe and warm today.
Thank you. You too, Mr. Chairman.
Next up is Lisa Amatruda. Ms. Amatruda, whenever you're ready, you may begin your testimony.
Thank you. Good morning, Senator Sampson, Senator Flexer, Representative Mastro Francesco, Representative Blumenthal, and members of the GAE committee. My name is Lisa Amatruda, and I'm the Republican Registrar of Voters in Woodbury. I'm the chair of the Litchfield County ROVAC, representing 26 mostly small towns in Connecticut, and co-chair of the ROVAC Legislative Committee. I'd like to thank you for making this bill concerning elections one of your first priorities in this legislative session. We very much appreciate that. I would like to add testimony to raise bill number 226, an act concerning various revisions related to the election process. I strongly support number 3, the use of the elimination of envelopes for early voting. Most importantly, this gives voters confidence in the security of election process and allows them also to correct their ballot if they overvote or make some other kind of mistake. Plus, this is highly requested by the voters, and as a side benefit, it will reduce the costs associated with processing these ballots on election day. I also support number 16, the FOIA question or section. This will treat referenda ballots the same as election and primary ballots. I oppose 4 parts of this bill, numbers 1, 4, 14, and 15. 1 is the early voting locations. I also believe, as others have stated, that the tiebreak should go to the town clerk first, and then, if necessary, to the legislative body. Number 4, this one is the same-day registration. So requiring moderators for same-day registration is another unfunded cost for towns, especially small ones, against the staggering cost of elections. SDR locations are not polling locations, and therefore a moderator has not been necessary. In most towns, actually, the SDR is located in the registrar's office or nearby. The registrar, who is also moderator certified, ensures that all regulations are met in the SDR location. To give you a little bit of perspective, the number of SDRs in all of Litchfield County for the last 3 years was, in 2023, there were 215. In 2024, there were 2,509. And in 2025, there were 231. That averages under 10 per town in municipal and gubernatorial elections and under 100 per town in presidential elections. Requiring another poll worker that is moderator certified is not necessary and would cause another unfunded mandate for towns. Number 14 is the log for rejected absentee ballots. With the unknown ways in which no excuse absentee ballot will work, this should, as a minimum, wait until the process has been worked out. Moderators and registrars often work late into the night to get results tabulated and reported into SOTS, and this would be one more task to slow that process down. I have personally witnessed my town clerk give comprehensive training and instruction to voters, and I'm sure that this is true of town clerks across the state. Number 15, the recanvass process. I think personally that it's important to keep our recanvass process focused on the contest and race in question, not expanded to add more people into the process. The recanvass is already open to the public, and any member of any party can come and witness the entire process if they choose. In closing, again, I'd like to thank you very much for making this bill a priority. Allowing voters to insert their own ballots into the tabulator during early voting will make many residents and poll workers of Connecticut very happy. Thank you for listening to our feedback and comments as registrars. Please let me know if you have any questions or would like any additional information.
Thank you very much for your testimony. Are there questions from the committee? Seeing none, appreciate your testimony with us today, and thank you very much for contributing your insights. All right, I believe, Mr. Clerk, does that bring us to the end of our list of witnesses?
Yeah, number 3 still declining to become a panelist. So
Right, and let me just double check one thing. Who was number 3 again? I'm sorry, Mr. Clerk.
it's Miss Peggy Leon.
Sorry. So Peggy Leon, if you're out there, you've been invited several times to become a panelist, which is what's required in order to speak and give your testimony. If you'd like to give your testimony, please do accept that invitation. Otherwise, we will close the hearing. I see Peggy Leon on the screen. And I believe if you unmute yourself and put on your video, you should be able to testify. All right. Well, appears that Ms. Leon does not wish to testify today. If that changes, please do submit written testimony and we will be sure to review it. And with that, we thank everyone who's contributed their testimony and all the questions from the committee. And with that, I will declare this public hearing of the Government Administration and Elections Committee closed. Thank you, everyone. Stay safe, stay warm, and we'll see you soon.